Hi all, good evening. Am I audible?
Good evening, sir. Yes, sir.
Yeah,
Good evening, sir.
yeah, very good
Good
evening.
evening, sir.
Yeah, can we start with the session?
Yes, sir.
Yes, sir.
Yes, okay. Before moving into the main part of the session, now we have done with three papers in law, right? So three papers in CA final, correct? So it might have gone well, it might have not gone well, nothing to worry. If it has gone well, excellent. Use that confidence to focus more on law so that you can maximize your marks. If it has not gone well, just forget it. Take that as a motivation and put more efforts in law so that you can compensate for those three subjects. Okay, so with that, we'll start with today's R2R session on CA final, corporate and economic laws. Okay, so we have studied hard, we have put in all our efforts. We have for the next few days we have to study hard, no matter if it seems impossible, it might be difficult, no matter if it takes time, be patient, no matter if you have to pull up all night, just remember that the feeling of success is the best thing in the entire world. Okay, the day of the results, when you see pass group 1 group 2, that is the best day in your life. The efforts that you have put is worth it. Okay, so with this, our plan of action for this session: first 10 minutes generic about the examination. Yes, you have written three papers, so nothing much in detail, just a brief reminder. Next 25 minutes specific about this exam, where we have to focus for the next 1.5 days. The last 5 minutes, obviously, some motivation general discussions. Okay, so no subject specific questions, no technical discussions. Okay, last exam of group 1, so give your best. After this exam, after Sunday, 50% of CA final is done. So give your best in the law paper. And we all know question paper has two parts. It has MCQs and descriptive. MCQs for 30 marks, descriptive for 70 marks. MCQs, no separate preparation. Read the question carefully. Okay, there might be some tricky questions which we may not be able to grasp in the first reading. So read the question twice before answering it. Okay, then fill in the OMR correctly. This is very important. You would have filled in the OMR today in auditing paper. You might answer the MCQ correctly, but while filling in the sheet, while shading the answers, while shading the option in the hot seat when you are sitting, you might go wrong, right? So please be careful while filling the OMR, filling the answers in the OMR. Then don't skip any MCQs. Obviously, no negative marking unlike CPT. So answer all the questions. Descriptive type, 70 marks, though the question paper is for 88 marks, you have to write for 70 marks. Read the question carefully again here. Write the best question first. Okay, there are 2 points here why we should write our best question first. First thing, when we start with the best question, the confidence level improves, the nerves will settle down in the exams, so confidence will improve. Second point, from the evaluator point of view, when he takes your paper, the first answer, if it is perfect, then the impression on that paper would be good, so the chances of getting higher marks will be there. Then if you feel you don't know the answer, read the question again. Read the question again. There will be some hints given in the question. They sometimes they give from which section point of view you need to answer also, right? So read the question again, you might be able to remember the provisions again. Then format of answering, we need to have a proper structure while answering the questions in CFNL law. What happens, we should divide the answer into four parts: provisions of law, facts of the case, analysis, and conclusion. Sir, do we need to bring in the headings also? Not required. Just four different paragraphs. First, start with in accordance with the provisions of so and so section of the Companies Act. What is the provision? Relevant provision is sufficient. If a section has 8 points, which point is relevant, only that point if we bring in, that is sufficient. We need not bring in all the 8 points. Then facts of the case, what is the current scenario in our hands, that facts of the case. Now analyze the facts based on the provision of law, so that your analysis, finally, whether the contention of the company given in the question is correct or not, contention of the director is correct or not, whatever is the requirement of the question in the part of the conclusion. Okay, that should be our approach. Don't quote wrong sections. other faculties also would have told about it. If you know the subsection, subclause and all, write it excellent. If you don't know, nothing to worry, just write the section number. If you don't know the section number also, if you remember from which chapter it is coming, the study material has the headings of the chapters in the study material is taken from the chapter headings of the bare act. Okay, so if you know from which chapter this provision is, if you remember the chapter heading, you write that chapter also, that's sufficient. If you know that it is coming from appointment and qualification of director chapter, then as per the provisions of appointment and qualification of directors chapter of the Companies Act 2013, that is fair enough, that is sufficient. Okay, however, if I don't remember the chapter name also, just write Companies Act as per the provisions of Companies Act 2013, but don't make the blunder of writing wrong sections. Then, to make your presentation better, you can use charts, tables, the approach that we follow in caps, arrow marks, that can be definitely used. And importantly, focus on writing qualitative answers than quantitative. Okay, we are not sitting here to fill in pages. Each requirement in the question paper will be allotted marks. So if we just satisfy those requirements, we will be awarded full marks. We need not completely write the history. Okay, so specific to the point. Then the reading time that we get, 1:45 to 2 o'clock, it is very important. Please utilize the reading time properly. Just go through the question paper once, then you will get to know which question I'm good at, which question is the best answer that I can write. Start with that question, and you can also decide in what order I have to write the answers. Correct? So you have to utilize that properly, and you can use the last page for refuse. We all know. So what we can do in the reading time that we get, at that point, whenever we were recalling the answers, if you feel that we might forget those points at the end while writing the answers, what we can do, soon after you are allowed to write write the paper, that is at 2 o'clock, you just jot down all those points in the last page, so that when you start attempting that particular answer, you can come back, refer to those points and build on that answer. Then frame the answers in your mind before writing. Just don't jump into writing the answers. Frame your answers in the mind, bring down the steps in your mind, so that you can have the same flow in the answer paper. Simple language, you need not bring in hyphen language, you need not reproduce the bare act, but use some appropriate words, use the keywords that is important for that answer. Okay, legible handwriting, we all know where it is sufficient if it is able to read and understand, if the evaluator is able to read and understand. And speed, unlike FR, we need not rush here. Okay, speed is not an issue in law. So what we have to do, we should also not go too slow. What is our normal speed? You have to maintain that normal speed. Why? When we are rushing through, then our mind is training ourselves to write fast, write fast, write fast. So we might not be in a position to give our best answers. Right? It is not completely focused on writing best answers. Whereas if we are writing in our normal speed, that is subconscious. So our mind is free. Mind will be thinking on which answer is the best answer, what I have to write, what I have to write. Right? So maintain the normal speed from the start. Don't accelerate in between, and you'll definitely we can complete the paper. It is not an issue. Write correct question numbers, preferably write all sub questions of a particular question at one place, and write the question number in the middle. Don't use the margins. Okay, then attempt extra question also. If time permits, write the answers if you know. If time doesn't permit, at the last fag end of the examination, just write the question number, write one line of that sub question. Why? Because if there is any out of syllabus question there, they might award grace marks, and since you have attempted, you will get the grace marks, and best of the five, obviously they'll choose. If paper is standard, nothing to worry, it is tough for everyone. Okay, evaluation will be easy. So our job is to just complete the paper and come. And don't stop writing until 5 p.m. You have put in your efforts for the last 2 years, 3 years, for what? For these 3 hours. Correct? So sit until 5 p.m. Write until 5 p.m. In case you have completed the paper in advance, no problem. Read the answers that you have written. There might be some corrections, there might be some improvements to be made. Right? So please utilize these 3 hours completely, and don't relax up to 5 p.m. The first R is extremely crucial. Okay, the first determines where you will end up with. Okay, because the first R how much marks you get, that determines the next 2 hours, your mindset. If you are getting sufficient marks in the first hour, if you are confident of it, next 2 hours will be pressure free. So that's the reason we suggest to start with MCQs, because at best MCQs 30 marks can be attempted in 30 minutes. Okay, so within that 30 minutes, if you are properly prepared, properly answered, 20 marks definite. Correct? So with that half an hour, we got 20 marks. In the balance half an hour, if anyhow we start with our best answer, right? Even if we write for 8 marks, 6 marks definite, right? So 20 marks plus 6 marks, 26 marks, we'll take 25 marks in first hour. The balance minimum I have to get is 15. I have 2 hours. The pressure is completely gone, right? So we might, that helps us to bring in our best in the next 2 hours so that we can maximize our marks. Okay, so first hour is crucial. Make it your advantage, take it to your advantage and get the maximum marks. Then take all stationaries including calculator. Sir, law, theory, why calculator? You will get practical questions. You will get practical questions. At that time, even simple calculations become difficult. So please take calculators. Fine. With that, we'll go to the subject specific corporate and economic laws. We all know we have company laws and other laws. Company law 65 to 70 marks, other laws 45 to 50 marks. So question paper is around 118 marks, 88 plus 30. Company law, we can divide it into 5 clusters: directors, meetings, and KMP, one cluster, 25 to 30 marks. Yes, it is time consuming and also it is standard. Lots of issues are there to be looked into. Inspection, inquiry, and investigation, prevention of oppression and mismanagement, compromise arrangements, and amalgamation. Yes, the title looks big, the headings of the chapters looks big, but the chapters are very small and very easy. Okay, we have to just spend some time there. All are procedural in nature, very easy to learn. 10 to 15 marks definite. NCLT, special codes, foreign company, miscellaneous provisions, which has 4 to 5 components, which we'll subsequently discuss. All these put together, 20 marks for sure. And all these topics are very easy and simple. Only thing is we need to spend some time in that chapters. Then winding up, it is lengthy, but extremely easy, very easy to grasp, but it is lengthy. 5 marks. Then drafting resolutions. Off late, after introduction of MCQs, they have stopped asking questions from this chapter, that is drafting resolutions and all. But to be on a safer side, we'll prepare for it. Other laws. Coming to other laws, we'll have 3 clusters. First cluster, IBC, PMLA, and SARFAZI, extremely important. 20 to 25 marks we'll get, and the quantum of syllabus there is limited. Okay, IBC, yes, there is something to read there. The quantity is there, but the marks that it carries is higher. Definitely 10 marks for sure. PMLA, very small chapter, 9 marks definite, one 6 mark, one 3 mark definite. Apart from that, they can also ask in MCQs. Very small chapter, PMLA, please focus. Sarfasi, one question for sure, small chapter, but this exam, this is the last time they can ask questions from this chapter. From the next attempt, they cannot. This is out of syllabus. So please focus on this Sarfazi chapter because they can ask 2 questions also. Then SEBI, LODR, SCRA, and FCRA, 10 to 15 marks. It is time consuming, these chapters, but they are important from the examination point of view. LODR for sure one question, SCRA and FCRA also for sure one question each. However, SCRA again last examination, so they might ask 2 questions also. Then the last cluster, FEMA, Arbitration and Conciliation Act. These two time consuming and also one question each from both the chapters we'll get. So focus on that also. Now, with this, all the topics are important. In law, we cannot say from this particular area they cannot ask the questions. We cannot say that, especially now in MCQs they can ask anything, right? So nothing can be skipped. Having said that, we will now discuss certain areas wherein we have to focus. Okay, I'm not telling the other topics need not be revised. Other topics have to be revised. These topics, little extra effort we have to put. Appointment and qualification of directors, section 149 to 172, the first chapter. Don't revise for more than 2 hours. Okay, here time is a constraint for us. We'll have on an average 20 hours left for us for preparation after taking all the miscellaneous hours. So we have to utilize this 20 hours for our maximum benefit. So not more than 2 hours for this chapter. The special points to focus here are minimum and maximum directors. There are exemptions and special resolution articles stating the number of directors. So focus on those chapters. Aspects, directorships, maximum number of companies in which he can be a director, and public companies, those provisions. DIN procedures, procedure for allotment of DIN, procedure for surrendering the DIN, procedure for change in the particulars of the DIN. This is important because in one of the examination they had asked surrender procedure for surrender of DIN. So simple, easy, but we might miss it, right? So just focus on it within. Just if we glance it, it is very easy for us to answer. Then rotation and retirement, total directors, out of which we should have some rotational directors. In that there will be retiring directors, correct? Retiring directors will be reappointed. In what is the procedure there for reappointment? If the AGM is adjourned, what happens? In the adjourned AGM, if he is not appointed, what happens? What is the position? So those concepts we need to discuss. Section 160 appointment, go through the procedure, special notice and deposits. Procedures we need to focus on. Then additional director, casual vacancy, alternate director and nominee director, extremely important. Out of these four, one question for sure. Okay, so here we have to focus on the approvals required, where they are appointed, and the tenure for which they are appointed. From those 2 points that they generally ask the questions. Then women director, applicability for which companies, and vacancy, what happens in case of vacancy of women director. Then small shareholder director, who can appoint, that is who can present for appointment of small shareholder directors. There are certain limits there, and also in what situation small shareholder directors office will vacate. Then independent directors, obviously applicability for which companies. Then there are certain qualifications with regard to independent directors that they have to comply with, and there now they have independent directors data bank, right? Examination. So those particular concepts just focus into. Then separate resolution for appointment, small concept. For each director's appointment, separate resolution has to be passed, not club. There is an exception there, so just go through that. Disqualification, 164 has two, 164 1 and 2. 164 1 has some list of disqualifications, 164 2 has two scenarios. Go through that. Vacation, 167 has several lists wherein vacation of director happens. And what if a director whose office is vacated do not vacate the office, consequence, that provision. Then resignation, just to go through the procedure. Removal, just go through the procedure, focus on that special notice, and we have to give representation. We need to give an opportunity for him to represent in the general meeting. So those provisions. Next, meeting of the board and its powers, section 173 to 195, max 2 hours. Frequency of board meeting, we have exceptions there. Then video conferencing, very important, rule 3 and rule 4. Rule 3 talks about the procedure. Once they had asked just to provide the procedures for video conferencing, just we need to list out those procedures. Then rule 4 talks about the exceptions wherein video conferencing cannot be done, right? Then quorum, again they have there is exception for section 8 company, and we have some concessional quorum for interested directors. In case of interested directors, that provision. Circular resolution has 4 conditions to be satisfied to consider it as a circular resolution. Focus on those 4 conditions. Powers of the board, 179, specific focus on 179.3, list of the activities for which board meeting is required. In that, 3 can be delegated. To whom it can be delegated, focus on. Then restrictions on the powers of the board, section 180. There we have 4 cases wherein special resolution is required. Go through those 4 cases. Then contribution to charitable fund, political party, national defense fund, similar provisions. However, charitable fund has a limit of 5%. More than 5%, what is the approval required? Go through. Then loan to directors, 185, very important, normally prohibited, however has certain exceptions. Go through those exceptions. 186 is procedure, complete procedure on LGSI, loan, guarantee, security and investment. There is limits, 60%, 100%. If it is below 60%, 100%, what is the procedure to be followed? More than 60%, 100%, what is the procedure to be followed? Simple. Related party transaction, who are related parties, what are related party transactions, and what are the approvals required. Again, we have limits here, 10% of the turnover, 10% of the net worth, etc. So based on that limits, procedure. Less than the limit, What is the procedure? More than the limit, what is the procedure? What approvals are required? Then disclosure of interest. We have general interest, specific interest, 184. Go through that. Committees, we have 4 committees: audit committee, nomination remuneration, stakeholder relationship, and vigil mechanism. All 4 focus on the applicability for which companies, focus on the constitution of the committee and the roles and functions of the committee. Then section 192, non-cash transactions with the director. There is generally it is prohibited. However, there is some exception there. Go through that. Then the third chapter, appointment and remuneration of managerial person, section 196 to 205, max 1 hour. Managing director, whole-time director, manager, we have the definitions. Go through. Then tenure of appointment. Then we have additional disqualification in 196 apart from 164 for an MDA, whole-time director and manager. Go through that. Then mode of appointment, we have 2 modes: Schedule 5 mode as well as central government approval. If under Schedule 5 mode, then we have to look into part 1 conditions of Schedule 5. So extra additional qualification requirements we need to look into. Then we have managerial remuneration. 2 cases: adequate profits, inadequate profits. If we have adequate profits, go through that limits: 1%, 3%, 5%, 10%, and 11%. If it is inadequate, again go to Schedule 5. Part 2 talks about effective capital, calculation of effective capital, extremely important. You might get practical question. So calculation of effective capital, based on the effective capital, we have remunerations listed there, limits listed there in part 2, 60 lakh, 84 lakh, etc. Based on that, our remuneration will be determined. Then compensation for loss of office for MD, whether compensation can be given or not, in what cases compensation cannot be given, and to what extent compensation can be given. Then appointment of KMP, who are the KMP to be appointed, in which companies they are to be appointed. Secretarial audit, just look into the applicability of secretarial audit, for which companies they are applicable. Then inspection, inquiry, and investigation, section 206 to 229, max 1 hour. So here we have inspection, inquiry, and investigation. Inspection has 3 routes. Section 206, all the 3 routes is under 206 only. First route, ROC can do the inspection based on the scrutiny of documents. Second route, ROC can do the inspection based on complaints by some parties or based on the directions by central government. The third route, central government will itself order inspection when by itself by appointing inspectors, or it can authorize any statutory authority. So go through that procedure of inspection, section 206. Then we have investigation. Again, we have 3 types here: 210 investigation, 212, and 213. 3 types of investigation. 210 investigation is by central government itself. 210 has 2. Central government may do the investigation, may order the investigation in certain cases. Go through that. Second part of 210, central government have to order investigation when tribunal directs. Then 212, serious investigation, SFIO, investigation by Serious Fraud Investigation Office. Go through the procedures. 213, investigation into other matters. There we have again 2. Here in our investigation is ordered by the tribunal. So tribunal, when it will order the investigation, when there is a complaint either by shareholders or by any parties. Complaint by shareholders when there is a limit, certain group of shareholders only can apply, any reason. Whereas other parties, if they make a complaint, there should be for a specific reason which is listed there. There are 6 reasons listed. Just go through that procedure. Okay, procedural aspects, powers of inspectors, all general provisions. There are some small provisions: power to seize books, who has the power, at what time they can seize books. So those things, power to investigate related companies. Then what is the follow-up action that central government or tribunal can take when the inspection report is submitted. Then investigation into ownership. This is another type of investigation, 216. Investigation into ownership. Go through the provisions. In case of investigation into ownership, there will be restriction imposed on transfer of securities, etc. Just go through that provision, when they can issue the restrictions and when they can order for freeze of assets. And protection of employees. Generally, in case of investigation, if any change in the position of that particular employee who has cooperated in the investigation, tribunal approval should be taken. So protection of employees. Then immunity to legal advisors and bankers. Advisors and bankers need not get complete information, only some limited information provided in the act. So go through that provisions. Then prevention of oppression and mismanagement, 241 to 246, max 45 minutes. There we have oppression and mismanagement first, wherein we need to discuss on who can apply for the relief under oppression and mismanagement. What orders can NCLT give? Those 2 provisions. Second, class action suit. Who can apply for the class action relief under class action suit, and against whom it can be applied? Then what can NCLT order? This. Then we have compromise, arrangement and amalgamation, 230 to 240, max 45 minutes. Here, compromise and arrangement, there is a procedure. Okay, just to go through that procedure. Then in amalgamation we have six methods, section 232 to 237. First we have normal amalgamation, 232. Procedure is exactly similar to C and A, compromise and arrangements. Okay, then 233, fast track merger, wherein there is a specific provision on who can apply under this section. Go through that and go through the procedure is a little different than normal. 234, foreign company, very small provision, foreign company can be merged with the Indian company can be merged with the foreign company. 235, procedure in case of amalgamation for transfer of shares, procedure in case of purchase of minority shares. 236, two separate procedures are there, just go through them. Then 237, order of merger or amalgamation by central government in public interest. There is some provision there, procedures are mentioned there, let's go through that. Then a small chapter, NCLT, NCLAT 407 to 434, small chapter, so 15 minutes is sufficient. Order of NCLT, where we can appeal. NCLAT order can be appealed to Supreme Court. There is time limit, 45 days, 60 days, condonation, extension. Just go through that provisions. Then companies incorporated outside India, 379 to 393, 30 minutes. Foreign company definition, extremely important. They are focusing mainly on our understanding of this definition of foreign company, 242. In that definition, there is one word called electronic mode. If transaction happens through electronic mode, it is also a business activity in India, so it will be considered as a foreign company. So what is that electronic mode? There is a rule. There are list of activities which will be considered as electronic mode. Go through that list also. And miscellaneous provisions, like what are the annual returns to be filed, what is the due date of filing of other documents by the foreign company. If foreign company wants to raise money, it can issue prospectus. Certain additional points that they have to keep in mind apart from the prospectus provisions that we have learned in CA Inter. Then compounding of offenses, adjudications and special courts, 30 minutes. Types of offenses, we have to understand compoundable and non-compoundable offenses, what are the differences, and all offenses are non-cognizable. Under that there is one exception, 212 subsection 6 offenses. Then mediation and conciliation panel, just to go through the procedure. Special courts, just go through the provisions. Miscellaneous provisions and topics, reasonably lengthy, 1 hour 15 minutes. We have 5 concepts here: removal of name, punishment for fraud, dormant company, registered valuer, and nidhi company. Removal of name, frequently asked. Okay, so there are 2 ways of removal of name. One, ROC itself will strike off the name, various reasons, and company can apply for strike of name, same reasons. However, 2 important points in company application is company should have no liabilities and special resolution to be passed. Then there is procedure for removal of name, go through that. Some companies cannot apply for removal of name, restriction, go through that list. And any party who is aggrieved by the order of the removal of name can appeal to NCLT, go through that provisions. Then we have punishment of fraud. There, section 447, there are 2 punishments, 2 penalties rather, for less than 10 lakhs and more than 10 lakhs. Go through that penalties. Then general penalty 450. If there is no specific penalty in any of the provisions of the Companies Act, then for such offenses, penalty under this section, general penalty, go through that. Dormant company, main focus is on significant accounting transactions. There we know that 4 transactions specifically given there are not significant accounting transactions, so just go through that. Then procedure for application of dormant company status, certain companies cannot apply for dormant company status, ineligibility. Then reapplication for active status, what is the procedure? Then we have registered valuer, who can act as registered valuer, eligibility and qualifications, that is given in the rules. Then nidhi company, basically they're asking questions based on rules, focus is on rules, nidhi rules. Okay, there are rules regarding incorporation, minimum members, net owned funds, term deposits, share capital, dividend, deposits, loans, directors and returns. They might ask in MCQs, so just have a glance of nidhi company rules. Then winding up, 1 hour 15 minutes. Types of winding up: compulsory and voluntary. Compulsory winding up by tribunal, which is discussed in this chapter. Voluntary winding up, IBC. So when can a company be wound up? There are certain cases, circumstances. Who can file the petition? 4 people: company, contributory, ROC and central government. Go through when they can file the petition. Filing of statement of affairs, audited accounts, etc. There is a time limit given for the company to submit these documents. Then There are two committees in winding up chapter: advisory committee and winding up committee. So why they are constituted, what is their role, just focus on that. Stay of suits. When the petition is accepted by the tribunal, all other petitions will be transferred to the tribunal except for petitions in High Court and Supreme Court. Go through that. Contents of liquidator's report, there are many contents, remember 5 to 6 contents. Set off, if a contributor has to pay call money, if he has to receive some amount from the company, can they set off that? Go through that. Share calls, who has the power to make the call of shares. Then arrest of person leaving India in case of absconding cases. What cases, who can order and when they can order, against whom they can order arrest. Go through that. Then we have order of payment, preferential creditors and overriding preferences. Very important, you can get a practical question here. So just remember the list of preferential creditors. Okay, so with that we can solve the problem. The last two provisions in winding up: fraudulent preference and transfers not in good faith. So basically violations of the priority of creditors. In that case, the transactions will be void. Go through that provisions. There are exceptions there. Then drafting the resolutions, as I said earlier, not much focus in the examination. However, go through the hints given in the material. Inverted commas, resolve that shall be in capitals. Start with the provisions. Resolve that pursuant to the provisions of so and so section of the Companies Act. And just go through some sample resolutions, that would be sufficient. Now, other laws, SEBI Act and LODR regulations, 1 hour 30 minutes. Constitution of SEBI, who are the members, who can be the members, removal of members, who has the authority, powers and functions of SEBI, and there is a list of penalties in SEBI. Go through that. Then adjudication and appeal, appeals in securities appellate tribunal, Supreme Court, etc. Those provisions. Insider trading, focus on price sensitive information. Who is an insider? What is insider trading? Then in LODR regulation, composition of board, that is different from the composition of board that we have learned in Companies Act. So their reference is also given to executive and non-executive directors, right? In committees, same audit committee, nomination relation and stakeholders relationship. Apart from that, there is risk management committee. So here, same composition of this committee we need to focus on. Audit committee composition, the last 4 exams, 2 exams have asked from LODR point of view. Then disclosure requirements, various disclosure requirements regarding related party transaction, proceeds of IPO, business responsibility statement, change in directors, etc. Just go through CEO, CFO certification, when it is required, and what are the quarterly and annual compliances for a listed company. There are various compliances, filing results, corporate governance report, etc. Then FEMA, 1 hour 30 minutes, reasonably big. Definition: resident in India and person of Indian origin. Very important. Restriction on dealing in forex and foreign securities. There are certain restrictions given in the Act, so go focus on that. Capital account transaction, there we have prohibited list, permissible list. Current account transaction, there we have Schedule 1, Schedule 2, Schedule 3. So go through that. Then acquisition and transfer of immovable property outside India, restrictions, procedures are there. Export of goods and service, just go through the procedure. There are certain provisions like we need to receive money within 9 months. If not received, what is the consequence? Go through that. Adjudication and appeal, common provision. Then import guidelines, just glance through the procedure. Sufficient. ECB, external commercial borrowing, go through the procedures. Overseas direct investment, ODI, there are 2 routes: approval route and automatic route. Just go through that. Then we have FCRA, 30 minutes. Definition of foreign contribution, important. Then what foreign contributions are prohibited, what are allowed, there is a list. Then when registration is required, when prior permission is required. Then what is the power of central government to prohibit or restrict foreign contributions? There is a list there. In what cases they can restrict. And to what extent I can utilize the foreign contribution for administrative purpose. There is a limit of 50%. In case 50% is exceeded, what approval is required. And then adjudication and appeals. Arbitration and Conciliation Act 1996, 30 minutes. Requirement of arbitration agreement. Arbitration agreement is compulsory. What are the contents? What should be the contents of arbitration agreement? Just go through that. There are some 8 to 10 points. Then what matters can be referred to arbitration, what matters cannot be referred to arbitration. There is a list. Go through that. Types of awards. There are 4 types of awards that an arbitration can give, and against that award appeals can be gone. Then cost. What constitutes cost? there is a list, and how is that cost shared between the parties. Okay, then conciliation, meaning of it, then what matters can be referred to conciliation, difference between arbitration and conciliation, then conciliation proceedings, procedure. Okay, then we have SCRA, very important because last exam. Then 1R, recognition of stock exchange. There is a procedure, conditions to be satisfied. Then withdrawal of recognition, at in what circumstances they can withdraw the recognition. Against that order, the stock exchange can go for an appeal procedure. And grounds of delisting, important, in what cases they can delist the companies. Then definition of derivatives, definition of securities. Certain contracts are notified by the government as void and illegal. Which are those contracts? Section 13 and 14. Then title to dividend. There could be certain extension of time given in case of transfer of shares, in case of death of the transferee, like that. To go through that provisions. Power of SEBI to inquire, power of SEBI to amend the bylaws, power of central government to supersede the business of recognized stock exchange. Three procedures, go through that. Then you have a list of penalties, you have to revise that. Then PMLA, 45 minutes, very important. Definitions, these definitions are extremely important. Definition of money laundering, proceeds of crime, property, scheduled offenses, part A and part C, payment system, then punishment for money laundering, then obligation of the bank, financial institution, or intermediary. What are the obligations? There are many obligations given, like maintenance of KYC documents for certain number of years of that particular party. So there are certain obligations. Then we have suspicious transaction and cash transaction. What is the meaning of those two words? Then we have suspicious transaction report, cash transaction report. What are the contents of those reports? Okay, then attachment, very important. Attachment, when it can be made, how it is made, and appeals against the attachment, attachment of property in the sense. Okay, then adjudication and appeals. Sarfazi Act, again important, last exam. Definition of default, NPA. Then registration of reconstruction company, procedure. Cancellation of registration, procedure. Asset reconstruction, what is the meaning? Provisions of that asset reconstruction. Then what do you mean by enforcement of security interest? Who can enforce the security interest? How will they enforce the security interest? Those 3 points we need to revise. Then there are certain transactions which will not fall under Sarfazi Act, exemptions. Please go through that list also. Then the last topic, IBC, 1 hour 30 minutes. Definition of corporate guarantor, financial creditor, operational creditor, corporate debtor. Registration of insolvency professional, initiation of CIRP. Who can initiate? Financial creditor, operational creditor, corporate debtor. Procedures, if it is initiated by financial creditor, procedure if initiated by operational creditor, procedure in case of corporate debtor. Who cannot apply for CIRP? Time limit to complete 180 days plus some extension. Moratorium order, for what period, what is prohibited at that time, what is allowed at that time. Then interim resolution professional, who will appoint, what is his role. Committee of creditors, what is the constitution of that committee and role of that committee. Meetings of the committee, very important. What is the quorum of the meeting, whether video conferencing can be done, and who can vote in the meetings. Appointment of resolution professional, who can appoint, what is his role. Then there are certain actions which can be taken only with the prior approval of committee of creditors. Which are those? Then information memorandum, what is that? What is its contents? Resolution plan, what is that? What are its contents? Liquidation process, go through the process. Preference transaction, similar to preferential creditors in winding up. There is preference transaction and priority, from which we can expect a practical question. Then fast track CIRP, what is the procedure? Who can apply fast track CIRP? Then voluntary winding up, just go through the procedures. Okay, so with this we are done with the technical aspect of the subject where we have to focus on. Then apart from this, I will not suggest about the timetable that has to be followed. You would have already planned, just go with that. Whatever makes you comfortable, just go with that. You will get the confidence. Now what I suggest is, on the day of the exam, Sunday, up to 10 o'clock, whatever revision you want to do, please revise and complete. From 10 to 12, focus on this last point that I have mentioned, specific revision of penalties in all chapters. Now I have not focused here on penalties in any of the chapters, right, apart from couple of chapters. So in all the chapters there are penalties. Please focus on that. Please revise those penalties at the end, because they are asking questions on penalties. Then resolutions required. In certain cases board meeting resolution is required, in certain cases special resolution, ordinary resolution in general meeting. Those, please revise it once more. Then limits, where independent director is applicable, where women director is applicable, so applicabilities in what cases, and maximum minimums, all those limits, please go through once more. Then RTP of May 2021, this attempt as well as the previous one November 2020, please go through, because questions can be lifted from it. Then, if time permits, whatever material you are using to revise these 1.5 days, at the end, just turn the pages, just read the headings of it, so that you will remember the provisions, you will recollect the provisions. In case if you are not able to recollect, just quickly go through, you will be able to recollect. Okay, with that, the preparation would be sufficient. Now just go to the examination hall with a positive attitude and mindset. You are a chartered accountant for yourself. It is just you are going to the examination for telling the institute that you are here. Okay, with that attitude, go to the examination hall and give your best. Don't panic. You have put in all the efforts, you will definitely get through. Okay, and today you have finished your auditing exam, so you'll be exhausted, so you can cover some small, simple and easy topics. From tomorrow you can go with the complicated ones. As I said, no specific timetable. What works for you, please follow it. Okay, so with that, believe in your efforts. You become what you believe. If you want to become a chartered accountant, you believe that you can, definitely you can become a chartered accountant. Now you have put in the efforts for the last 2-3 years, correct? Now it is you are in the final stage. You are so close to the victory, correct? Don't give up now. Have the same focus, have the same patience. For few more days, success will be yours, definitely. With that, repeat after me: I can do this. Yes, thank you. All the very best. Enjoy the law exams. You will certainly pass. Okay, thank you very much, everyone, for sparing this precious time. I hope this session was a helpful one.
Thank you, sir.
Thank you, sir.
Thank
Thank you,
you,
sir.
sir.
Thank
Thank you,
you.
sir.
If anyone has anything general clarifications or anything to talk, I'll spare a minute, else we'll end the session. Okay, good to go? Fine.